Well, hello everyone. You guys just missed it because I was talking to myself for 2 minutes thinking I was live. And then Larry's like, Mandoo, are we're not live, right? I'm like, oh. So that was funny. I'm glad none of you had to see that. Thank you so much, Larry, the hero of the Mandoo channel, who single-handedly saved us from the evil copyright strike non-do-gooders in Louisiana. Many of you might not be aware of it, but the channel was being struck down. It was off. I didn't know what to do. And out of all people, Larry reached out to me, and I'd reach out to a lot of people. Larry reached out to me, and he said, Mandy, how can I help? And he was instrumental in saving the channel. So thank you, Larry.
I do what I can.
And then what the purpose of today is that I was watching as we do in Mandoo, we watch parole and commutation hearings out of Louisiana. And they had a commutation hearing of a man who was given a life sentence without the possibility of parole. And for what? For knocking his attorney unconscious in court. Okay, so he was being tried for something completely different. His attorney, whatever it may be, we'll get into it. We'll watch the case and then we'll discuss it. He knocks him out, and the DA and the judge, they drop all the charges that he was initially there for, and they gave him a life sentence without the ability for parole.
You're leaving out the best part, Mandoo. I mean, I wouldn't call it the best part, but like the most iconic, I think, scene in this whole debacle. Because what you're calling knocking out, in reality, was after getting hit on the side of the head near I think it was the left side, near the skull, the eye socket area. The attorney is laying on the ground unconscious for several minutes, bleeding, ends up laying in a pool of his own blood. They don't even know if they're going to be able to bring him to. Eventually, he comes to and goes to the hospital. So allow me to be a little bit more graphic. This is not just he knocked him out and now he's back. This was a serious blow to the human body, to the human skull. Like when I read that, I was not ready for it.
That's definitely true. It was not a little backhand slap. It was violent, but I think what makes this case particularly interesting and why I wanted to bring you on was what happened at the end of the commutation hearing. So it's more than 20 years later, and the same attorney shows up to keep him locked up in prison for life. And the things that he says struck me as odd, to say the least. So I don't know how you want to approach this. If you want to watch the full hearing and then jump in with comments. It's from start to finish. It runs for 37 minutes.
I mean, has your audience seen it before?
No. I've been waiting to watch it with you.
Roll tape.
Let's do it. All right. 1, 2. All right, I have to click this button, right?
And I have to fix this. I don't know why this is showing up. This should not be up there because I have the paid version of IV Cam. I just haven't used it in a while. But
well, you're I guess you're what's wrong with freemium, right?
Right. Well, no, I pay for it because I like it. So I don't know why. I guess I have to like reset it or whatever. But ignore me.
It's like that awkward moment when your Zoom call shuts off 20 minutes in because you're not paying for it.
Oh yeah, and you have to restart. I remember those days. Who pays for Zoom? Like
who pays for Zoom? I know. Okay, so let's jump in.
Do we have audio?
Yeah, this is
Mark? Yes. Okay, all right. And both of you want to speak, and we'll call on you at the appropriate time. We'll let them know you're here. Okay. Okay, are they ready? All right, we are ready for our next case. Mr. Spano, would you introduce yourself? Tell us your name and your DOC number.
Good morning, Ms. Renata. My name is John Spano. My DOC number is 367260, ma'am.
Yes, and for the record, I did not state that we are now convening at Louisiana State Penitentiary. And so before we get started on your case, I'd like to have the staff there at Angola. Please introduce yourself for the record.
Deputy Warden Rochelle Ambo.
Reginald Lamoureux, classification.
Jane Babel, offender record.
And everybody? Okay. And I'd like to ask your attorney to introduce himself for the record, please.
Good morning, Tanner Woods, here on behalf of John Spano. Thank you for y'all's consideration, and we're excited to meet the case.
Okay. And we'll usually do that at the end. Is that okay with you after the interview?
Yes, absolutely.
And also here with us in Baton Rouge, Mr. Spano, is family members Mark Peters and Jill Peters. And both of those folks want to speak on your behalf, and we'll ask you to do so at the appropriate time. First, I'm going to just read some identifying information, and then we'll start the interview process. Mr. Spano, as stated, your DOC number is 367260. You're here today seeking a commutation of your sentence. You were sentenced in October 2006 in the 1st Judicial District, Caddo Parish, as a habitual offender for second-degree battery, currently serving a life sentence. Is that correct?
Yes, ma'am.
All right. Your case this afternoon has been assigned to Mrs. Jackson.
You sounded
You
so
answer her
proud.
questions.
Good afternoon, Mr. Spano. How are you doing?
Good afternoon, Ms. Mott Jackson. I'm doing good. How about yourself?
Fine, thank you. How old are you?
I am 45, ma'am.
When do you make 46? Next month, right?
Yes, ma'am. In August?
11.
Yes, ma'am.
I'm putting you down for 46, okay?
Yes, ma'am.
And how much time have you actually served in this case?
In this case, ma'am, I got incarcerated in 2002, so almost 20 years.
Hey, Mandoo, can you pause it real quick?
Yes, sir.
We actually got a really good question, and I think I don't know about you, but I think it would be prudent for our audience to start with this so that people understand what's happening.
Let's do it.
Can you share the screen that I just shared? Okay. So you sent me this. This is the Court of Appeals opinion, or a portion thereof, of the State versus Spano case. Now, just so we're clear, there are a couple of moving parts here, because Spano was charged with some felony, which I haven't gotten into because I literally just received this information from you. Maybe you can fill us in. And he was getting ready to go to trial with his attorney, Ricky Swift. Ricky Swift is the one that ends up getting knocked out by our protagonist here. But before we even get there, I mean, Ricky Swift and Spano are in court getting ready to go to trial, and then all of a sudden Spano says, well, I have a new lawyer. And then there's kind of like a scuffle, and they kind of go back and forth, and they come back to the counsel table, and Spano is like, well, I'm not gonna be serving a life sentence or something along those lines. You're not gonna give me a life sentence. You're trying to get me a life sentence, something along those lines. And pop, knocks his attorney out, gets charged with second-degree assault, gets convicted. That's another felony on his record. Is this hearing directly related to him trying to get on parole for the assault battery, or the original conviction, if and when that happened?
Yeah, no, I'm glad you asked. So this is a commutation hearing. So he was given a life sentence without the possibility for parole. In Louisiana, what they've done, because they've considered it maybe, they've given the opportunity. So if a board says, we'll recommend a commutation, then the governor signs it, then he has a chance at parole. So right now he's sentenced life. He's getting buried under the jail. So it's even tougher for prison. And that's what this is for. And it's for this specific case. It's for knocking out his attorney. The reason why he was going to go to court, those charges were dropped. Now, he was going to court not for anything. It was for he was accused of sexual assault. He insists that he was innocent, and that's what his attorney was supposed to defend him on. But they dropped those charges.
So the original basis for this trial that was going to happen on July 12th, 2004, those charges have been dropped.
Yep, they just said, forget about it. We're not even going to trial. Let's just get him on this.
Well, yeah, because you have witnesses. It's literally I mean, the worst place you can commit a crime is inside the courthouse with cameras, with witnesses, bailiffs, judges, prosecutors, defense attorneys, all watching this whole thing. I mean, and who's not gonna call them on as witnesses? You know what I mean? Okay,
Exactly.
so that's the backstory. Okay, roll tape. Sorry, I just wanted to fill our audience in because people had questions, and I thought it would be prudent.
No, please do. This is your show. This is
It's your show. I'm just a guest.
Well, you're the attorney, so let's bring in as much as your. Okay, so let's. Where are we here? Bring this back to front. How do we? Oh, here it is. Okay.
Got it.
Got it. Good.
Okay, so this incident didn't actually happen until 2004.
Yes, ma'am.
You were incarcerated on the rape charge, is that correct?
That is correct, Ms. Jackson.
Which was ultimately dismissed as a result of your being found guilty of second-degree battery and being adjudicated as a habitual offender and receiving a life sentence. Is that correct?
Yes, ma'am.
So you've been in since 2004, actually serving time for this charge.
Yes, ma'am.
So tell us what happened, Mr. Spano, in the case that you're incarcerated for right now. Tell us what happened.
Ma'am.
So that's the attorney who we're blocking's view. What do you want to do? That's the attorney that he knocked out. That
Can
just came in.
There's like what is it? Control 7, I think. Will put us on the side of the screen rather than on the bottom.
Yeah, so I see.
It's either Control 6 or Control 7. I can't remember.
Let's try. Hopefully this doesn't like whoop. Well, I see this. No.
There you go.
Oh, there we go. Okay, so let's do that. So that's him, Mr. Swift.
And also, since we got Mr. Swift in the picture now, let's take a moment and introduce our second protagonist. So Ricky himself, apparently, as you have disclosed to me, which I'm going to share with our audience now, he is also a class act in and of himself. Back in 2014, let's see if we can zoom in here. No, that's not what I want. You zoom in on this. Oh, there we go. All right. Attorney disciplinary proceedings. That is definitely not something you want to see with your name attached to it. I will say that for sure. So per curiam means the entire board of the disciplinary council in Louisiana, Supreme Court of Louisiana is sitting. So they have all members. No one is recused or anything like that. The Office of Disciplinary Counsel commenced an investigation. This is 10 years, mind you, 10 years after the knocking out incident, and 9 years before we are here today on this hearing that we're going to resume in just a second. So the Office of Disciplinary Counsel commenced an investigation into allegations that respondent, which is Ricky Swift, filed a frivolous lawsuit, engaged in conduct prejudicial to the administration of justice, and I believe in his capacity as a public defender, because at the time of the writing and at the time of the incidents, he was a public defender, and he may still be a public defender. I don't know that for a fact, but as of 8 years ago, as of the writing of this, he still was. He threatened to bring disciplinary charges against another attorney solely. Now, this is the key, okay? So up until this point, filing a frivolous lawsuit, okay, that sucks, engaged in conduct prejudicial to administration of justice. All right. Threatened to bring disciplinary charges. You either bring them or you don't. You don't threaten them. You can't make it a condition of, if you don't do XYZ, I'm going to file a bar complaint against you. You can't do that. That is an ethical violation, like literally the definition of an ethical violation. If you're going to bring disciplinary action against another attorney, just do it. Don't say you're going to do it. Just do it. And then the bar committee will decide what to do. But he did it. Not only did he threaten it, he did it solely to obtain an advantage in a civil case. I mean, literally, when I read that, my first thought was, oh, every scene in that show, Suits.
It almost seems like blackmail in a way.
It doesn't seem like it is blackmail, because you're basically saying, look, I need you to do something. No, I'm not going to do that. Well, if you don't, I'm going to bring a disciplinary action against you. You're literally saying, I have something on you. And if you do, you're under an ethical duty. It's like a catch-22, because now if you know that they have committed an ethical violation, you're under a duty to report it. And if you don't report it, well, now you are guilty of failing to report an ethical violation. And if you're threatening that you're going to report an ethical violation, that means that you are automatically guilty of failing to report it as we speak, or you're bluffing, both terrible things. And if you're bluffing, that's the blackmail that you're talking about.
Now, to be clear, this what would you call it? An infraction, or this strike against him? It's not related to this specific case. It's just saying something about this attorney's history.
Yes, we're talking simply about Ricky's character and who he is as a person based on this one public reprimand. So they filed formal charges against Ricky, and the Office of Disciplinary Counsel, ODC, Office of Disciplinary Counsel submitted a joint petition for consent discipline. So they're not going to go into detail. They're simply saying, look, it is ordered the petition for consent discipline be accepted, and that Ricky Swift, Louisiana bar number such and such, be and hereby is publicly reprimanded. So he's not suspended. He's not disbarred. He is simply, it's like a scolding of the finger. Don't do it again. Everybody knows now. It's all public. Everybody's going to be talking about it. And it's out there. He is then placed on unsupervised probation for a period of 1 year, and he has to pay for the costs of this proceeding.
Now, out of curiosity, because he was accepted to the bar in 1985, so it's going on like 37 years or something that he's been an attorney, and I think a public defense attorney. Is it uncommon to have one strike over that span of a career?
Well, let me put it to you this way. A public reprimand means you crossed the line and you got caught. I think private reprimands are extremely common. Attorneys get privately reprimanded for little things that they do that maybe they shouldn't, and it's not unheard of, especially in a 37-year career. I think, and I don't want to be defending this man in any way, shape, or form because I don't know anything about him, but I think it's possible that maybe something led to this sequence of events. But here's the bottom line. It doesn't matter how heated an argument may be, because it may have been just in the heat of a moment or something like that. But Then again, it's a whole frivolous lawsuit that he filed. So it definitely wasn't a heat of the moment. He had to go back home, type up a complaint, read it, reread it, edit it, wait a few more days, look at it again, print it, go to the clerk's office, get it stamped, file it. I mean, it shows very conscious intent. And then to stack on top of it, to come in and say, if you don't XYZ, I'm going to file a bar complaint against you. I mean, that just shows the kind of person you are in my book. There's no coming back from that. Hence the public reprimand. Otherwise, it would have just been swept under the rug. Nobody would care. So in 37 years to have this strike like that, to me says he probably did maybe similar things before he just didn't get caught. But that's just one fellow's opinion. I have no evidence to support one way or the other. So, you know, you're asking me, is it common in 37-year career? I would honestly say no. I know my fellow cohorts who have been practicing, you know, 20, 30, 40, 50 years and have this many strikes against them. So I think this time he simply got caught, and maybe he was feeling a bit cocky. Maybe he had a pattern of behavior, let's say, that was just flying under the radar, not crossing the line. And this time he just, you know, crossed over the line and said, all right, we're done. We need to address this. And the opposing, because how did this come about? It's the opposing counsel. Whoever was on the other side of this that he threatened, more than likely, came forward and said, look, I can't sit by and be silent about this. You just threatened, you know, filing an ethical complaint against me. I have to go to the bar because you just committed an ethical violation yourself. And if now it's almost like I said, it's like a catch-22. If I don't say something, then I'm in trouble. You know what I mean? So it's a very complicated and nasty matter. And nothing against Ricky. I mean, he seems to be, you know, in 37 years, he seems to be doing all right. So Godspeed to him.
We're only speculating on a situation like this.
Oh, that's all we can do.
That's all, right. But let's go see. I think I think you might be onto something. It is interesting that an attorney would show up 20 years later to keep a man in prison for life for hitting him, in my opinion.
Foreshadowing much?
The attorney that I had assigned to the case filed ready and did all the paperwork. They removed that attorney right before trial, which was the weekend. They assigned me a new attorney, Mr. Ricky Swift. Mr. Swift came and seen me. He explained to me that he just got the case, that he was going to file a motion asking for a continuance because he did not file ready and there was no way that he could properly represent me. He did go in the courtroom and file the motion. They denied the motion. Also, he stood up and made an oral argument to be removed as counsel because he couldn't properly represent me. At the time, they denied that motion. When they denied that motion, I let my anger get the best of me, and I punched Mr. Swift one time, strike him in the face, which I do regret.
Why are you angry with Mr. Smith?
I felt as though
I did not sense any regret in those words.
Trying
He's
to
proud
mess
of it.
over me, ma'am, and
They
Mr. Swift did everything he could to help me. And at the time, I thought that the DA's office and Mr. Swift was working together, which after looking over the situation, I realized that Mr. Swift did everything in his power to help me. And I'm sorry for hitting him.
No, you're not.
You hit him once and he fell.
Yes, ma'am.
Did he hit his head on something?
I believe he suffered a cut in above his eye, ma'am, due to the punch.
I believe so.
I
You
don't
weren't
know if
even
it was from
paying
him
attention. You
falling. I
don't
believe
care
it
about
was
what
from
happened
him
to him.
getting punched, ma'am.
Not looking good.
So, you know, obviously I've got to ask you about the rape case.
Yes, ma'am.
What were the accusations against you in the rape case?
Ma'am, in that case there, I was dating a young girl. her fiance was in the military. In the night in question that she said she was raped, it happened in my parents' home. My mother, my father, my sister, and her daughter was at the house. As you can look at my record, I'm not a good guy. And her husband, her fiance at the time, was coming back from the military, and she went and told the sheriff's office that she actually told her friend that I had raped her in my parents' home. And I went, did the investigation. I talked to the investigator. I took drug tests because she said I was on drugs and everything. I passed all that. I was under full cooperation, and it was her word against mine. There was no evidence. The sheriff office arrested me.
It's not, I didn't do it. There's no
I
evidence.
pled not guilty. I stayed not guilty
Jesus
for
Christ,
almost
this guy.
2 years, ma'am, going back and forth to court. And I'm still not guilty of that charge, ma'am. I did not sexually assault that lady
Well, there he says it.
at no time.
Oof. I hear a lot of hesitance in those
All
words.
Well, you're actually, they ultimately dismissed the rape charge, and it may have been because you received a life sentence in this case, but I'm not going to speculate on, the merit of the underlying charge, because I don't have that information.
So what did you
for me.
ask about it if you don't
I
care?
do say,
Just wanted to hear
see
him. That's
that
fair.
in 1996, you had an aggravated battery where you received a 4-year sentence. What was that about?
Miss
so he's got a
Jackson,
history
that was
of battery.
a fight in high school. I was my senior year. Actually, 1995 should have been the date of arrest.
He's a
How old
recidivist.
were you in 1995?
I was a juvenile. I was 17 years old, ma'am.
It's a high
And
school.
what happened in the fight that caused you to get an aggravated battery charge?
Me and a couple of my friends was out. We stopped at a gas station. We had got into a fight with a group of guys. There was a chain and a tire tool. Some of the guys got hit with
Weapons.
different weapons. I threw a chain with a lock and hit a guy with it, and that caused me to get aggravated battery. I pled guilty to 4 years hard labor, ma'am.
So you were not probated, you actually served 4 years in prison?
Yes, ma'am. I never had probation.
You did not get a suspended sentence.
I wouldn't
Also-
call him a career criminal. He just
Also,
has
in
a hot
connection with
temper.
that,
He just
there was
doesn't know
a
how to control
cruelty
himself.
To a juvenile.
Yes, ma'am. In the process of the fight, there was a lady and a child at a red light. Someone hit the child. I took full responsibility for it. The lady said she could not identify no one.
Yeah, but when someone, either you hit the child or you did it or you didn't. So
I did do it because it was my actions that caused the fight, ma'am.
what happened to the child?
In the process of fighting, the child got struck at the red light.
Oh,
Like I said, it was a bunch of us fighting, and the child got hit.
That struck at a red light. Was the child in a car?
Yes, ma'am.
And the vehicle that the child was in got struck?
No, ma'am. I reached in the car and hit the child. There was another person in the car, and the child got hit in the process.
Now it makes sense. So one of the people that you were fighting with, was in the vehicle.
Yes, ma'am.
Okay, all right. And then in 2000, you had a simple battery.
Yes, ma'am.
What was that about? You got
In-
30 days in parish jail for that.
And what was the date, ma'am?
It was 2000.
it means there was more than those three if he doesn't remember the date.
You pled
needs
guilty to a
confirmation.
simple battery and you got 30 days.
Yes, ma'am. That was a fight in the city jail. I pled guilty to 30 days. I was in the city jail doing time for a traffic ticket and another violation, and had a fight while I was in the city jail with another offender.
You also had in 98, you had a simple burglary where you got 15 months in DLC. What was that about?
Me and my girlfriend jumped the fence at a man's house out in the country and trespassed on his land and went into his cabin and was swimming. Nothing was vandalized. The sheriff department got called and come and arrested me for simple burglary.
Burglary of what?
It was a hunting camp, a fishing camp.
Well, that's not bad. I thought he was going to say, and then he like knocked his cow unconscious.
And then I saw another simple battery that had started off as a second-degree battery. It got reduced to simple battery, and that was in 1998. Remember that?
Yes, ma'am. That Miss Jackson, that one there was also a fight in a city jail. I was locked up doing time for something else and had a fight in a city jail and with another offender.
Oh, why so many fights? Why so many crimes of violence?
Ma'am, for as long as I can remember, I had a problem with losing my temper. Most of the time dealing with arguments, and arguments lead to me getting into fights. I learned that was a main trigger in my arguments was cause my temper to have outbursts and everything, and I would get real upset. So with self-help programs, and I learned how to control it, help people instead of having
Notice the hands.
disagreements, listen to people.
He's just anxious. He just wants to get out of there.
Figure out why you were
What do I
so
need to
prone
say?
to get angry.
Ma'am, I had my bitterness and everything usually came from arguments and disagreements. And like I
So
said,
you're never going to
self-help
argue and disagree
programs
as soon as you
show me
get
that
out of here?
it doesn't have to
Sorry, can
be
you pause this real
angry
quick? I don't want to talk over this
disagreeing.
guy.
Why were you walking around with so much?
Well, you know, they do
Show
do
of
get
hands.
to it.
Show of hands, who does not believe a word that this guy says? I'm sorry. Like, I'm gonna call a spade a spade. Who here? Raise your hand if you don't believe a single word that comes out of this man's mouth.
Well, I can make a poll. We can see. You know, it's interesting. What I find fascinating about these hearings is that you go through a flow of questions, and your opinion might change. Because we're going to learn things about his record. You know, if they're going to ask him how many fights has he gotten into in the last 20 years in Angola, and maybe his answer is going to surprise you.
No, sure. I'm saying at this juncture, 14 minutes and 32 seconds into the video, at this moment, because I can't predict the future. You're absolutely right. But like my spidey sense is tingling. You know what I'm saying? Like everything that this man says is literally designed to get him the most favorable result with this board right here, right now, so I can go back to business as usual. There is no rehabilitation in my mind. Again, my own opinion. This is just my opinion as a make-believe board member on the Louisiana Parole Board.
Yeah, no, it's fascinating. We're all gonna, you know, the opinion may or may not change as it goes. And just for the FYI, it's not a 56-minute long hearing. It's so it's only about like another 15 minutes longer, and then we can go into more commentary. But
I want to hear what the attorney has to say, because apparently he says a couple of things.
That is what we're looking forward to. But let's see. I'm curious, and I'll run a poll on the chat and see what everyone else thinks.
Anger, that's what I'm trying to figure out. What were you angry about? Who were you angry? I mean, why so much anger?
I didn't have anger, ma'am. It was mostly, my temper.
Temper and anger are the same thing. What do you mean?
Well, I would lose my temper at different things and at arguments and disagreements. I learned how to control it.
And how do you control it? Tell me how you control it.
I control my temper, ma'am, by positive thinking. I listen to people now instead of arguing. I offer self-help, and I learned that you don't have to argue or disagree with somebody. You don't have to result in violence, that you can be a better person.
I do
So,
see that
Coach.
you've only had one write-up that was in 2009, was for a contraband. What was that about?
That was stamped envelopes, ma'am. I had in my possession stamped envelopes.
Where'd you get them?
I got them out the canteen.
Purchased them?
Yes, ma'am.
They sold them in the canteen?
Yes, ma'am.
Why was that contraband?
Because they said the amount that I had in my locker box.
What did you have?
I had, I believe, 400 and something.
Okay. Why'd you have so many?
Mailing hobbycraft out, writing letters. Guys get stamps and don't need them, give them to me. I wrote a lot of letters, mailed a lot of hobbycraft out to my family. I did not realize that they was contraband, and they actually gave the stamped envelopes and everything back to me after I pled guilty in court.
You've been a minimum age trustee since
So that I'm not sure I believe, because stamps is a currency. So if you have 400, I think it means he's probably trading it or running the store.
2015, is that correct?
Yes, ma'am.
What's your job at the prison right now?
I work maintenance, ma'am.
Specifically, what do you do?
Air conditioning, refrigeration, and carpentry.
Okay. And I do see that you got a letter of commendation from the maintenance department supervisor.
Yes, ma'am.
So he's got good work ethic.
You also have
that to him.
very positive remarks on your institutional record. So I see you've only taken correct me if I'm wrong, you've taken 100 hours of pre-release, cage arranged, and living in balance 1 and 2.
Yes, ma'am. And I am currently thinking for a change.
How long have you been involved? Living in balance with the substance abuse program. What were your substance abuse issues?
My substance abuse issues was drinking, ma'am.
How old were you when you started drinking?
Say 15, 16, hanging out with older friends.
What kind of drinking did you do?
Mainly beer, ma'am.
How often were you drinking?
Usually on weekends, Miss Jackson.
Did ever progress to other alcohol or to drugs or to more frequently than on weekends?
No, ma'am, it never progressed to drugs. I had never had a drug problem. But once I got older, I started going out after work, drinking with friends on weekdays and stuff like that, Miss Jackson, but never heavy drinking.
How many days a week did you go out drinking?
Maybe 2-3 days a week,
Plus weekend?
plus weekends, yes, ma'am.
What do you call heavy? That sounds kind of heavy to me.
I'm heavy drinking is like what I would say drink all night long. I wouldn't do that
God.
because I always had a job. I would go out for a couple of hours, drink, and go home.
What did you learn about your drinking habits and living in balance?
Ma'am, I learned that even social drinking can be a problem if it's not controlled. I learned that
He's a binger.
when you social drink, and as I did, if there was an argument or anything like that, it would lead to me getting into a fight or me leaving a bar or someone's house mad or losing friends over that. So I learned that I attend classes weekly here in Angola and express that and help other people dealing with that, and they help me. I did learn that, man.
So you do
He's
see a
just- I did learn
connection
that,
between
like,
alcohol
get off my
and-
back.
and anger and temper.
Yes, ma'am.
So how do you plan to avoid that?
To prevent that, ma'am, put myself around positive people, continue go to church, continue working, and just avoid drinking, period.
That should have been
I
your
don't
first
need it in
answer,
my life.
dumbass.
It's been destroyed most of my life, man.
Well, how are you gonna be able to avoid drinking? Because your friends are gonna want to go out. You'll be at social events with your family. There'll be beer and maybe other liquor. How are you gonna avoid
Great
drinking?
question.
It's gonna be all around you.
Well, ma'am, I can avoid it by drinking Coke, drinking Dr. Pepper, drinking water. I do not have to socialize with people and drink. I have learned that.
I do
can
not. He's distancing
socialize with people
himself.
and drink
I
water.
will not is the right answer. I do not have to
Taking
do
anything
that.
like
But I
AA
will.
or NA.
We do a AA program nightly at Camp F, ma'am.
Go ahead.
I go up there and fellowship with the guys and fellowship with them outside of the AA.
When you say fellowship with them, what
Thanks,
do you mean?
Bojan.
I mean, sit down, talk, discuss problems, discuss different
I know
situations.
that's not how you pronounce your name. I just felt like saying that.
So you're
Help.
actually participating in the AA meeting.
Yes, ma'am.
You think AA or NA is something that is important for you on the outside?
I think AA is, ma'am, and I think people with positive outlooks and on life and just in general is church. I attend church services, Cowboys for Christ at Camp F. There's all kind of services that have positive things in them.
How important do you think it is to attend AA meetings? As
I think-
part of your plan to maintain sobriety?
I think it's real important, ma'am.
So tell me, because when I asked you what was your plan, you kind of didn't mention AA, you mentioned church and people. Didn't hear you mention AA as being part of that sobriety plan.
Well, church, the 12-step program it's church based and it's founded on that. So church, AA goes hand in hand. I do think that both of them are real positive. If released, I will attend both of them, ma'am, because I need that.
Notice how,
So,
pause.
Talk about transition plan.
Up until this point, notice how this is extremely important. I notice witnesses do this all the time, especially cops on the stand. His hands have been on the table the entire time, almost the entire time for the last 24 minutes. As soon as he said, I'm going to be going to church if released, ma'am, his hands immediately went under the table. He's hiding something. He's lying. That's a very telling language, by the way. It's not guaranteed, but it's when something like so extreme happens in body language where he's been doing the same thing for 23 minutes, and for the first time we hear words like, if released, I'm going to do XYZ, and his hands disappear. That is a 100% pay attention.
I didn't. You know, you have much more experience. I'm not a body language guy, but I thought maybe he's just starting to feel comfortable, so he's you're left stiff.
No, when you're comfortable,
So-
you're gonna be doing this. You're gonna be showing the palms of your hands. I have nothing to hide. The first thing he does, he takes his hands and he puts them under the table where you can't see them. That is deceptive language.
Yeah, I hear you.
Yeah, but that's again, it's you can never rely on body language as an tell all and be all. Like you're not gonna, use that to crucify someone, but it's definitely an element to be paying attention to for these things. I noticed that immediately. I mean, I don't know if anybody else in the audience has caught that, but that was just so. And that is the first time he said anything about if released. Did you catch that?
That's true. It's well, I guess we'll. I wonder if they will release him on this note too. But
Yeah.
I've seen hearings that have gone much worse. I think like this is probably like somewhere in the middle, like not a 1, not a 10, maybe a 5. Just because I've seen over 600 hearings, and believe me, they can be so much worse than this.
Oh, I'm sure.
Yeah.
I mean, this guy's keeping it together. Listen, don't get me wrong. I have not had as much experience watching these as you have. That's for damn sure. But I will say from this one, watching this one, like you said, he's most certainly keeping it together, and he's definitely he knows what are the right things that he needs to say in order to at least have a shot at getting out. But the problem is what he is missing is the human element behind it, because it probably doesn't exist. No offense to him. I mean, if it was there, we would hear it, like I want to bring you to, have you seen Shawshank Redemption?
Of course.
Okay, of course, right? I would imagine you would.
Right.
Do you remember Red's hearing, the third one that he did? So,
Right. Yeah.
for those unfamiliar with the movie, it is about a man who is allegedly wrongfully convicted, but we don't know that until much, much, much later in the movie. And without spoiling, because even saying that, I still have not spoiled the movie because it's a phenomenal flick, and I urge every single one of you to watch it. There's another main character played by Morgan Freeman, and his name is Red, and he's in prison for, is it murder? I can't remember.
Red Rum, maybe.
Anyway, so Morgan Freeman's character, he plays him so well. His name is Red, and he's basically like, he gives up hope. He's like, I'm going to be in this prison forever. I'm never going to get out. He has a parole hearing every like 5-10 years. And each time, if you listen to the words, if you listen to the emotion behind the words, like the first time he appears before the parole board, he's like, oh yeah, I'm rehabilitated. No question, ma'am. No question about it. I'm 100% a changed man. Let's go do this, And then I think they do another one. And then the third time, and again, this I won't spoil because an event happens that changes Red's perspective on life. A couple of events actually happen. He has a conversation, and then an event happens with our main protagonist. And he has that final hearing, and you have to watch the movie. And it's like the raw emotion that is felt behind the words all of a sudden, because we genuinely feel his words. We don't just hear them. Like with Mr. What's his name? Spock? I forgot his name.
Who the
Spoke?
Spano?
Yeah.
Yeah.
Spano.
John, I guess his first name is John, but they're calling it Mr. Spano.
Mr. Spano. So Spano, like I hear him. I am listening to his words, but I don't feel his words. They just like they're landing on sand rather than water.
No. I do agree with that. There are certain people that are very charismatic in these hearings, and he's more reciting, and I do agree.
Successful, where would you live? Where would you work? How would you support yourself?
Ma'am, I have a skilled trade of heating, air conditioning, refrigeration. I also have an EPA hazard chemical license that goes with the refrigeration. I have a resident plan at my sister and brother-in-law's house. I also have a job reference plan with a guy that owns a construction company. I would support myself by getting a job with him, and I would live with them.
Them being,
My sister, Mark Peters, my sister, Jill Peters, and my brother-in-law, Mark Peters.
Warden, what can you tell us about Mr. Spano?
Okay, I can tell you that Mr. Spano is a Class A trustee. He have worked outside detail. He has did renovations at the governor's mansion, and he's also when LCIW was moving to Jetson. He was part of the work crew that that renovated the Jetson compound for the women to be transferred there. He helps with renovation of houses and repairs of houses on the B-line for the B-line community. And he also do air condition repair. And he is in AA. Only one DB report, and it was the one that you spoke of. And I heard him say that they gave him his stamps back, but they only gave him the $50 allotted limit for the stamps. The rest of them they confiscated.
All right. That's all I have, Ms. Egan.
Okay, thank you. I have just a couple questions for you, Mr. Spano. Just listening to you. Tell us, when's the last time you got angry?
The last time I got angry was about 3 months ago, ma'am. And I got angry because it was at a job and we was doing an install and somebody wanted to do things their way because their way seemed easier for them. And it would have been easier for me to do it my way, but I compromised with them and let them do it their way, and eventually got the system hooked up, and then came back later on and showed them how the book says do it and explained to them after everything got calmed down. I resolved the situation by doing that, thinking instead of acting.
All right, good. So I was going to ask you the last time you disagreed with someone, but I guess that was it.
Yes, ma'am.
Okay, all right. What kind of handicraft do you do?
I do metal work, ma'am.
Okay,
Metal, jewelry.
all right. I don't have any other questions, and I want to acknowledge that we have also on Zoom your sister, Miss Diane Sprayberry.
Sister.
We'd like to hear from you now, ma'am.
Hello.
Yes. What would you like us to know?
I would like you to know that he means a lot to all of his family, and that we know that over the years that he has changed and he has tried to do better. And that he is very family oriented. And I would like for you to know that if he is granted his pardon or parole, that we will do everything that we can to help our brother stay on the right track.
Yes, ma'am. Thank you for your remarks today. And we'd like to hear from
Thanks.
the
That was really
other
short.
sister. Could you step up to the podium?
Thank y'all for letting us be here today. I just want to say that we think that John needs a second chance because he's done so good in Angelic, been there 23 years. He's been very good. Got all his certificates, so I think he's ready to get out in the world and show what he's done. And we'll take care of him, don't you worry.
Okay, thank you.
Thank you.
Mr. Peters.
Thank y'all for having us today, and I just want you to know, thank y'all and the system for changing this man, making him a real man instead of a young, angry fool. And we have seen it every time we go down there, we get acknowledged how good he is and how well he participates with everything. And the system does work, whether people believe it or not. He's living proof of it. And I just want to thank y'all for giving us this chance. Thank you.
Thanks for being here. We do
Ricky
have
is just
also
like,
on Zoom.
Give me my turn.
is-
Give me my turn.
It's actually no, but it's actually refreshing when they go through the three supporting statements. It's all under a minute. Sometimes they just ramble on about nothing, and it's actually doesn't help anyone.
Fair,
It's just-
fair.
yeah.
Respect.
Mr. Ricky Swift.
Here we go.
Yeah, he's still there. I have an indication that he does not want to speak. But I will
Oh.
give you that opportunity, Mr. Swift, if you'd like to say a few words.
He does not want to speak.
You're on mute.
Can you hear me now?
Go
Okay.
ahead.
Yeah, I would just like to say briefly, in 30 seconds or less, that I did represent Mr. Spano, and I heard what he said. I would differ that I was not prepared, but I was trying to assist him in getting his case continued because that was his request. However, many times the defendant will wait to the last minute and tell the court that they plan on hiring an attorney. And that was actually the situation, that the day of trial, Mr. Spano announced to the court that he was hiring an attorney, and the court gave him an opportunity to have that attorney come in and represent him. Of course, that didn't happen. So therefore, the court denied the continuance based on it was an attempt to delay the trial. And lastly, I would like to
Delay
let
tactics.
the panel know that Mr. Spano had every opportunity to go to trial and prove that he was not guilty of this rape. The reason he hit me is because he knew the evidence against him was overwhelming, that he would be convicted, that once he's convicted, I informed him that he would be multi-bill and receive a life sentence. And that's why he panicked, because he really didn't want to go to trial. So he was looking for a way out, and his way out was to hit me in order to avoid being convicted of the rape. So that's all I want to say.
Oh, wow. Okay. So it was not as bad as you painted it, but it's a different kind of bad, Mandoo, because you painted it as a different picture in our conversation. I thought it was going to be a whole lot worse than this. Delay tactic. Let me commit another felony just so that I don't have to go to trial on this felony. I mean, this guy is something else. And for some reason, I actually believe Ricky, because it actually makes sense in a way, because he has a history of violence. He knows that the way to solve an argument is by punching the other guy harder than he punches you. And it's a solution to problems in the man's head. Unfortunately, it's, again, not judging him, simply trying to assess what's probably going on in his head as an individual. He gets angry. He gets frustrated. He got angry in court because he was like, my lawyer's not prepared. I don't want to go to trial. If I go to trial today, I'm going to lose because my lawyer doesn't give a shit about me. And it doesn't matter if it's the truth or not. He believed it, and therefore it was his truth. And so when he saw Ricky like getting his papers together and getting ready to go to trial, in his head, Spano is sitting there going, we're going to lose. I'm going to go to prison, because Ricky admitted just now, he said, I warned Spano that there's overwhelming amount of evidence against him. You will get convicted and you're going to get a sentence. And meanwhile, Spano is sitting there going, all right, Ricky doesn't care about my case. He's not going to be representing me to the best of my ability, to the best of his ability. I'm probably going to get convicted. I need to find a way out of here. And especially because I think we didn't really read this part, but in the opinion, I believe the court stated that the delay tactics, so there were two delay tactics attempted, one failed and the other one succeeded. The first delay tactic that Spano tried to implement, and Ricky just mentioned it, is, Your Honor, I hired new counsel. The morning of trial, all of a sudden, you don't wait a week before, a month before, a day before, the morning of, jury's about to walk in, Your Honor, mulligan, we got to start over. I just hired new counsel. That's delay tactic attempt number one. And the court to that said, if you read the opinion, the portion that I read, this is where it says in the facts, that the court was going to say, no problem, you can have your own attorney, but the trial is still going today. The trial is still going to go today. If you read under facts, I believe I saw it somewhere because I read it. And so after that fails, so a new attorney is going to come in, is not going to work. What is my second best option? Oh, if I punch a lawyer out, commit a new crime, we can't proceed forward. And so that's his, unfortunately, it's not committing. Somebody called him a career criminal. I don't think he's a career criminal. I really disagree with that statement. I think he is, I don't even think he's a bad man. I don't think his intentions are bad. I think he is a good man with a good heart who just does not know how to control his temper and simply uses violence as a means to an end to accomplish his goal. So when somebody disagrees with him, somebody makes him angry, his reaction is to use physical violence to get what he needs. Maybe he was abused as a child. Maybe he grew up in an environment where that was the norm. Maybe he was part of a gang. I don't know. I have no clue. But this is starting to, like, I'm seeing the picture. I'm seeing the, like, more and more and more of this picture now. And I think Ricky Swift, his former attorney, has really filled in whatever gaps were missing. And it was a delay tactic strategy, and that makes complete sense. That's why I believe him. So
my question is, because what I heard was his attorney saying, I told him that he's going to get prosecuted. He's going to get an habitual offender. He's going to go away for life. And that's why he hit me. And as a defense attorney, aren't you supposed to believe your client? His client's saying, no, I'm innocent.
There's a difference between believing your client is innocent and believing your client is going to get convicted. I may believe my client is innocent, but knowing there is overwhelming amount of evidence that is going to convict my client no matter what I believe. Sometimes you believe your client is guilty and you still represent him because the state doesn't have enough evidence. You don't believe the state's going to prove your client's guilt beyond a reasonable doubt. That is the polar opposite of the statement you just made. So you got to think of it this way. My favorite phrase that I like to use: just because you did it does not mean you're guilty. Let that marinate for a second. I'm going to say it again. Just because you did it does not mean you're guilty. And that phrase, there's a lot to unpack there, but in a nutshell, it basically means you may have committed the act, you consciously know, maybe you told your attorney, whatever, but the state can't prove it. But the state doesn't have enough to prove your guilt beyond a reasonable doubt. And so you're going to win at a trial, even though you have committed the offense, but there's no way to prove it beyond a reasonable doubt. The flip side to that is there's a very famous case. It is also known in the legal world as an Alford plea. Have you ever heard of the case of State v. Alford, Mandoo?
I've heard it like contextually, but
it's very simple. It was a man accused of committing a murder. I believe it was a murder. I'm pretty sure it was a murder. He swore up and down, I didn't do it, I didn't do it, I didn't do it, I didn't do it. It wasn't me. Wrong place, wrong time, too much evidence. And because he said this new arm of the law was created, I am going to plead guilty to the offense, said Alford, but I maintain my innocence. It is the most insane construct of law that has ever been created, short of like Miranda and maybe a couple others I can think of, that can warp reality, like the Fourth Amendment even. It is basically him saying the state has so much evidence against me, and if this goes to trial, I am 100% going to lose. I'm going to get convicted. I'm going to get the max sentence, but I didn't do it. I maintain my innocence. Practically speaking, an Alford plea has absolutely zero effect on your sentencing. At the end of the day, you're going to get the same sentence that you agreed to with the prosecution, that the court, assuming the court accepts it. You're going to have the full force of a guilty plea. I guess the thing you do get to say, because we've had, sometimes a client will plead to like a speeding charge, extremely, 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 extremely rare. but they're like, I did not do it, but I'll just plead it to, get it off my back and get it over with. We had a lawyer in the courthouse. He was, God bless him. He always boasted about the one time he got an Alford plea on a speeding charge, because that was his claim to fame, and it was like his favorite story to tell. And it has no real effect on the plea itself and the sentencing itself. But you can go around saying, yeah, I pled pursuant to Alford. If you're like, apply for employment, I pled pursuant to Alford, which means, you can honestly say, I maintain my innocence, but there was overwhelming evidence of guilt against me, so I decided to just take a deal. And you can't, not every plea can be turned into an Alford plea. If the prosecution doesn't agree, if the court doesn't agree, you will not get an Alford plea pushed through. So we've pled some clients pursuant to Alford in my office, in my career. It's extremely rare. But again, it's one of these things, and I'm coming back to it, Mandoo, because you asked a very fascinating question. The way you phrased it to me yesterday was like something along the lines of the attorney himself believed his client was guilty. I don't think so. I actually disagree with that statement. It doesn't, Ricky did not use any words to denote that he believed Spano was guilty. To the contrary, he warned him. He stated that he warned him of the potential consequences of going to trial. He warned Spano of the amount of evidence against his client. He warned him that he might be spending the rest of his life in prison if he goes to trial and doesn't take the plea or whatever. He warned Spano of all these things. And again, we're coming back to the same question. What is Spano's response when he is angry and he's unhappy with the results and he's not getting what he wants?
He throws a dinger. There was a case with the Alford plea that I saw in the Louisiana parole hearing, which did upset me, and that was someone who had I call them cockroaches on this channel, a chomo, someone who harmed a child, and he took an Alford plea, and the DA let him, and I was upset with that because I said the victim wants to be believed, right? So I was surprised that they allowed in that case for him to take the Alford plea. But it's an interesting point of view. I when I had first seen this, I thought that he, that's what I reached out to. I said, his attorney comes 20 years later and then says he didn't even trust his client. But
let's listen to it again. I will even break it down if you want, not to its every constituent part, but the main pillars, I think, of Mr. Swift's testimony.
That opportunity, Mr. Swift, if you like.
Can you hear me now? Okay. Yeah, I would just like to say briefly, in 30 seconds or less, that I did represent Mr. Spano, and I heard what he said. I would differ that I was not prepared, but I was trying to assist him in getting his case continued because that was his request.
So pause right there. So I was trying to get the case continued because that was his request. My client told me, I don't want to go to trial today. Let's get it continued. Let's get a new date. And I will do that for you, Mr. Spano. And he asked the court. Court says no continuances. We already know that. We're moving to jury trial this morning, counsel. Let's go.
Because that was his request. However, many times the defendant will wait to the last minute and tell the court that they plan on hiring an attorney. And that was actually the situation.
Okay, pause. So it was a delay tactic, and he's explaining that to the board. It was Spano's attempt to buy more time.
Right.
Mr. Spano announced to the court that he was hiring an attorney, and the court gave him an opportunity to have that attorney come in and represent him. Of course, that didn't happen. So therefore, the court denied the continuance based on it was an attempt to delay the trial.
Didn't
and
get
lastly,
what he wanted.
I would like to let the panel know that Mr. Spano had every opportunity to go to trial and prove that he was not guilty of this rape. The reason he hit me is because he knew the evidence against him was overwhelming, that he would be convicted.
Okay, pause right there. I see what you're saying. He knew the evidence against him was overwhelming, is still not a conscious, in my opinion, a conscious admission that of like his client's guilt. He's saying his client knew. He's not saying I knew. He's not breaching attorney-client confidentiality. He's saying he has been given every opportunity to go to trial. He knew the evidence against him is overwhelming. Now he's about to launch into, and I told him how bad it's going to look and what the potential consequences are. So, yeah, roll tape.
Once he's convicted, I informed him that he would be multi-bill and receive a life sentence. And that's why he panicked.
He
because
warned
he
him.
really didn't want to.
But what was he telling him to do? Well, I mean, I still see it from him saying he hit me because I told him they're going to find you guilty. And when they find you guilty, you're going away for life. You're telling a 20-something-year-old kid this. And that's why he hit me. And if I'm sitting there innocent, and Larry, I got to tell you, I take this personally because I was falsely accused of doing something. Okay. And I found myself in a cell with 2 detectives on a Sunday morning. And I watched enough Law and Order to know to ask for an attorney. And I was 1010% completely innocent. So with that in mind, I couldn't be a jury on his trial, right? But I have certain perspectives and views where I just have a different perspective. So because of that, I'm gonna, I might believe him. But I wouldn't want my attorney telling me you're going to be found guilty and you're going away for life.
He didn't say that, though. He said there is an overwhelm. See, you got to be careful. Mr. Swift said that he told his client that there is an overwhelming amount of evidence against him. He never said, dude, you're guilty. What are you doing? He never said that. First of all, that doesn't even make sense because there's only 2 entities that can find you guilty, and that is a jury or a judge, depending on if you do a bench trial or a jury trial. So overwhelming evidence of guilt, and you have to separate in your mind fact from law, because I know it's not easy. For a lawyer, it's extremely easy because we do it every day. So bear with me. So in his mind, Ricky knows what happened because his client told him. Whether he believes it or not is completely irrelevant to the equation. On the law side of things, Ricky knows that the standard in court is beyond a reasonable doubt, guilty or not guilty. Well, beyond a reasonable doubt, guilty, or the opposite, not guilty. There is no standard on the not guilty. So on the law side of things, Ricky looked at the evidence, saw what the state has, knew what they were going to bring forth, assessed how a jury is going to look at it without bringing any emotion, bias, judgment, personal opinion into the matter, and assessed that Spano is going to get convicted by a jury of 12. And if he is going to get convicted, they're going to give him the life sentence, the maximum sentence, which is life. Therefore, there is no reason to go to trial. And what other alternatives do we have? There's probably a plea deal on the table. Dude, take the plea deal. Maybe it was 5 years, 10 years, 20 years. I don't know what it is. But whatever the deal was, he was probably urging Spano to take it. Spano said, no, I'm not taking the deal. I want to go to trial. So Ricky did his due diligence, as any public defender would, and said, look, man, if you are convicted, and I just told you there's overwhelming evidence of guilt against you. Again, what I personally believe doesn't matter, and what you personally believe doesn't matter. It's what the state has. You with me?
I am with you, and I'm going to bring something up once you're done.
So sure. And so finally, the Spano said, "I'm going to trial." And when he realized, I'm just going to keep delaying, his first delay tactic didn't work. We're back to square one. Punch him in the face, and we're good. I bought myself more time.
But I saw your last YouTube video that you loaded telling the secrets, and you said you're supposed to take it all the way to trial up into the last moment and then take a plea deal. So
That's not exactly what I said. You should always set your cases for trial to overload the system.
Right.
But I didn't say he was gonna go to trial. That's a different ballgame. There's a difference
Right.
between setting it for trial, and maybe you should go to trial if you think you can win, sure. But here you're gambling with a man's life, and if the state has enough evidence to convict, it's probably not a good idea to take it to trial. Does that make sense?
Yeah, no, that does make sense.
And the client is, at the end of the day, the arbiter of the case. They get the final say whether or not you're going to trial or not. So, but also you're forgetting the last piece here, because, and I don't think I mentioned it, because Swift was firmly convinced that he was going to lose, and unfortunately he projected his lack of confidence in Spano's case to him. That is the real reason why he got hit at the end of the day. It was a delay tactic mixed in with probably what Spano felt was justified. Like, dude, you're not fighting for me. You don't believe in me. You don't believe in my case. We're going to lose. I don't want to go to prison. And I'm just going to go to prison for something else, I guess. I don't know.
Hey, and that is the flip side. Imagine if he actually was innocent and he just sat in jail for 2 years waiting for this trial, and his family's supposed to buy him an attorney, but they don't. And then he's stuck with this public defender who then looks at him and says, you're going to go, you're right. If you have an anger problem, you might knock out your attorney too. Could go both ways.
It's a crazy, crazy situation, no matter how you look at it.
And the bottom line is he does show up 20 years later to keep this man locked up in prison, which...
Well, I don't know if he is exactly, I wouldn't phrase it that way personally. I would simply say that all he's trying to do is to be there and voice his opinion. Would you really go so far as to say he's there to make sure the man doesn't get out? I think he just corrected the record based on what he said, based on what Spano said about Swift.
Well, I don't know. He is showing up at his hearing.
So he was an involved party.
Well,
he's a victim.
I can't remember if he mentions it.
I don't know. I'm just stating what I see, man.
I hear you.
Want to go to trial. So he was looking for a way out, and his way out was to hit me in order to avoid being convicted of the rape. So that's all I want to say.
Yes, sir. And we did receive your victim impact statement that you submitted earlier. We have that in the record. All right. Before we turn it over to Mr. Woods, Mr. Spano, is there a statement you'd like to make?
Ma'am, the statement that I would like to make is I am on the backlog list for victim awareness. If I would have completed that course like I did apologize to Mr. Swift. I want Mr. Swift to know that I am truly sorry for hitting him and disappointing my family, ma'am. The people that care about me the most, I let them down.
All right, thank you. All right, Mr. Woods.
Thank you, Dawn. Let me start by talking a little bit about who Mr. Spano is.
This is his attorney now.
Yes, and I haven't known him for all that long. We just recently got hired. But I feel like I know him from the conversations that I've had with him already. I also grew up in the Shreveport area, and so I feel like I know this area. I know kids that went to Southwood High School like Mr. Spano. And I will say that most of the kids that I know at Southwood High School got into a fight or two in high school. That was, it is a very country sort of rural school, and fights happen, things like that happen. And I have no doubt that Mr. Spano, and I'm sure that he would agree with me, that he was a rowdy, rambunctious, high school kid. He got into some fights, he made some stupid mistakes. And his brother-in-law, who's actually been now with Jill for a little over 38 years, has been with him since John, they've been together since John was 12. He was one of the main, role models for John. He was telling John all along, that you got to stop this, you got to stop getting in all these fights, you got to be getting in trouble. At one point, I think he even kind of predicted the future and said, we're getting in trouble, something bad's going to happen. You're going to wind up in jail for a long time. Mr. Spano, unfortunately, didn't learn that lesson early enough. And he found himself on trial. And I just want to go back to that morning.
Found
or the
himself. What a
evening
way to phrase
before.
it.
The first time that he's ever met Mr. Ricky Swift, his defense attorney, he's going to trial for an aggravated rape charge the next morning. Mr. Spano knows, and he's got 6 witnesses. He was talking about him here today. He's got 6 witnesses, 2 of which were out of state. And that had been filed in motions indicating that they needed time to get the 2 witnesses from out of state here, and then he had 4 witnesses that were in town. He had a defense that he wanted to present. Mr. Ricky Swift had not been on the case long enough to understand that defense. And he panicked. He panicked. The motion for continuance was denied. The motion to withdraw was denied. And he panicked. And he made the worst decision of his life. I would ask y'all to not hold the rape charge. And it really is surprising to me that his own defense attorney is holding a rape charge that he was not found guilty of and that was ultimately dismissed. And he is arguing here today that that rape charge is the reason that he should spend the rest of the time. And I don't think that's true. There is a reason that the rape charge was dismissed. They could have continued to prosecute it. I know that if any of my family members were picking a charge like that, I would still want to prosecute it. I don't care that he's already been sentenced. I would still be pressing that it should be prosecuted. I think that the fact that it was dismissed shows that they were looking for the easiest and quickest way to have him sent away. He has done more. There is not anything else that he could have done since he's been incarcerated. He's had 1 write-up in 2009 over the 22 years that he's been in Angola, which is impressive in and of itself. He has worked a plethora of jobs. He's worked in the governor's range. He's been allowed to work at the rifle range around guns. He has been giving the most trust that any inmate in the facility could be given. He's a Class A trust state. He was even authorized to go off of Angola's campus to do different HVAC.
The guy in the blue suit is getting ready to go to sleep. Both of them.
I believe that all of this weighs heavily in the favor that he has learned a lot over the past 4 years. He is not the same person who is. He has learned how to cope with his anger. He's learned how to deal with disagreements. And I believe that he deserves another chance.
Thank you, Mr. Lewis. All right.
You know, the attorneys have a choice. They can sit in Angola next to their client, or they can be in the same room as the parole board. I guess he was playing it safe and being in the same room.
Oh, damn, son. You just called them out.
Okay. But I mean, I thought his final statements were interesting. He was kind of digging at Ricky Swift again, and he also made some good points. He has 1 write-up in Angola, arguably the toughest prison in the U.S. And I mean, that's to not be fighting there and to be trusted around the shooting range and all those things. I thought it was a good argument. And he said, you know, he had 6 witnesses that he didn't do the crime. 2 of them were out of state. He wanted them in the courtroom. Ricky Swift was new to his case. It wasn't the same attorney that was assigned to it. I thought he put up a good case. One thing I don't agree with him about is where he said if he was guilty, they would have prosecuted him. We've seen in Louisiana, the DAs don't really care about those type of cases like sexual assault. They don't care a lot. They don't like going to trial. They take plea deals.
Oh, you mean the
long.
defendants don't like going to trial?
No, the DAs. I don't know for certain how often not the defendant. How often you're saying the victim or the defendant? The DAs for
the prosecutor. Let's just
the prosecutors. For these type of deals, we often see where they take plea deals. There's no trial, and they have between 2 year, 6 year. The most we've seen is like, there's just a lot of short sentences, plea deals.
Interesting.
Yeah. Because there's a lot that can go wrong. You can have mistrials. There's a lot of them are broken homes.
Guaranteed sentences is what basically they want. They don't want to mess around.
Yeah, they just So.
Okay. Interesting.
Yes.
Mrs. Jackson?
All right, Mrs. Spano, I wrote on my notes, we'll decide after the interview. I wanted to hear you, wanted to see you, wanted to see how you react to things. I'm impressed by the fact that a person who has had so many issues with anger in the past and has spent your incarceration in Angola, and you only have one write-up. And that wasn't even for fighting or anything related to anger. And to me, that was impressive. You only had one write-up. Your institutional record is good, and you had very positive comments from your evaluators. You had very important, very positive comments from the maintenance department. And so my vote would be to grant your request and recommend commutation sentence 99 years.
Thank you, Ms. Jackson.
Mr. Mirabella?
I'm sorry, Miss
Thank you,
Jackson.
Madam Chairman,
I am
Mr.
for
Spano,
real.
I've listened
Exactly.
intently to what you had to say, and I've been in the criminal justice system for 50 years, so I understand how trials work. I understand how defendants and public defenders often have conflicts, and lawyers want, defendants want them to do more than perhaps what the lawyer can do. So I can understand how that was a disagreement. They did drop the rape charge. Don't know why, as Judge Jackson said, don't know why they dropped it. Maybe because they were going to get you with this charge, but they tried you for this charge as opposed to the rape charge. The rape charge was that strong. It seems to me they would try to that, but that's just my opinion. You made a excellent presentation today.
An
I
excellent
think you've had a good prison
presentation.
record. My vote likewise would be to recommend the governor that he can reach a sentence to 99 years.
Mr. Freeman?
Thank you, Mr. Murillo.
Colleagues, and I also vote to commit your sentence to 99 years.
All right, Mr. Spano, for all the reasons that have already been stated, my vote is the same. So on your behalf, sir, we're going to make that recommendation to the governor that your sentence be commuted to 99 years.
Again, not released,
Thank
but
you.
no longer
I
life
will
in
not be
prison, only
disappointed.
99 years.
Well, what yeah. So
I
what it
don't.
means, if the governor signs it, then it makes him, I think, immediately eligible for parole, and then he has a parole hearing, which is 99.9% like it's a shoo-in. I've only seen, I think, one case where after the governor signs the commutation that they deny.
Oh, wow.
Well, you think about it, the governor, not the governor nominates the commutation board. So if the commutation board recommends to the governor signs it, and then the same board denies it, he'd be like, "What are you doing?" So
I mean, look, I have no ill will towards this man. Obviously, I don't have a dog in this fight. I don't have. I wish Spano nothing but the best, but let's just say I don't have a lot of hope. If you were to ask for my personal opinion, I pray that I'm completely wrong. But what I also know is that I read people for a living. So just the vibe that I'm getting, I hope I'm completely off the beaten path and I'm completely wrong.
but why is that? He's in Angola. He has one write-up. Now that's not an easy feat in all the years that he's been there.
Mm-hmm.
He's excelled in prison. He's trusted. He did everything that he possibly could do to succeed. So what do you think is going to happen when he gets out that he couldn't?
He's going to go back to his old ways, and I'll tell you why. I feel this way. When you're in prison, you don't have access freely to access alcohol. You don't have the freedom to access drugs. You don't have the freedom to go
Not
from point A to
necessarily.
point B.
There are plenty of people.
Well, let me finish. Let me finish. I'm saying like uninhibited free access whenever, wherever, for the most part. Okay. You can't argue with that point, I don't think.
It's harder to get your hands on it, but if you want it, you'll get it.
Not my point. The freedom of access. But that's not the main point. When you're in prison, when you're basically in an environment psychologically, you have your routine, you have your space, it's familiar. You create certain patterns, certain new patterns begin to emerge. Alcoholics Anonymous, treatment programs, maybe more religious work, whatever you got to do, right, to survive. Upon release, what happens? Why do a lot of people, like drug addicts, for example, who are clean for years in prison, the minute they get out, they overdose and die? Well, or just go back to their old ways if they don't overdose and die. The problem is you are released back into the environment where you don't have those training mechanisms. AA did not exist in your, let's say, home environment, in your backyard. So you're going back to the environment where the triggers of previous events are now coming back. It's all a psychological hive, if you will, or like plotting dots on a graph, right? So you have at a centerpiece, you have the prison, and then here you have AA, and you have church, and you have hard work, and you have dedication, and all of this. Now, when you're released physically to an environment that is home, that is friends and violence and drugs and alcohol and all of this, you need to transfer this dot map, if you will, over to the new environment. And that's not an easy feat, especially if you have a history. And this man clearly has a history. And again, I wish him nothing but the best. Again, I'm not, like I said, I have zero interest in having this man fail. I hope he succeeds. But from what I have seen and the way he talked about his plan of action, once he gets out, there's no concreteness. It's all very vague. It's, I'm going to do this and I'm going to do that. Like a man who has his plan talks like this. When I get out, if I get out, when I get out, my plan is I'm going to do AA 3 days a week, every day at 6 p.m. at the church. I already have a plan of action in place. See, now you're transferring all those data points that you learned in prison onto where you're headed. And on top of that, Mondays and Wednesdays, my family and I are going to be going on a fishing trip, or I don't know, like make it up. I'm making it up, right? But when you're in prison, you have all the time in the world. You have a plan of action that you're going to create. In my mind, that would be the optimal way. Now, I'm not saying this is the only way, but I'm saying that's the way I foresee it happening. Again, maybe it's too much. Maybe it's overbearing, but the chances of success, and this is from a psychological standpoint, the chances of success, if you were to do that, are exponentially, infinitely higher, because now you are transferring all those learned skills onto the new environment where you're about to be released, where those triggers are still the same triggers. Doesn't matter, 15, 20, 30 years later, they're going to trigger you whether you like it or not, because that's just who you are. You haven't had a chance to practice those new skills in the non-controlled environment. Controlled environment, you got it to a T. But in the non-controlled environment, that's where you're going to have potentially going to have issues. So again, I wish him nothing but the best. I hope he succeeds. I got to go. I didn't realize what time it was.
Well, on that case, and it's fair. Recidivism rate is.
But I want to let you finish. If you have anything else to say, I don't want to just leave on that note.
The recidivism rate is what it is because you're right. It is really hard to get, and I've seen so many of these hearings. You're right. Many do come out with a very specific structure and a plan, and he didn't have that. I still kind of can't get over the fact that he was sentenced to life because he had like 4 previous incidents, including in school, where he was throwing fisticuffs, right? These aren't weapon charges. These aren't, and he was given a life sentence without the chance of being free. And that seems wrong. It just doesn't seem like justice to me. Being locked up for 20 years, and it might have been the best thing for him, like I think is one of his relatives said. And now it's up to him to stay out of prison. But that's and also to believe that he was not guilty of committing the horrible crime he was accused of committing.
Which is apparently irrelevant to this equation because that was dismissed. Yeah.
They're saying it's dismissed, and then it's up to you whether you want to believe he was guilty of it or not. He doesn't have a history of doing that, and you might argue someone would have a history of doing it. He doesn't have any sex offense write-ups in jail, which people who typically do when they have. So, I mean, there's a lot of but I'm so grateful that you came on. Again, it means so much to me. For those of you who don't know, Larry was my hero in Not All Heroes Wear Capes, and we've been in touch ever since. And then he said, "Yeah, I'll jump on. Let's do it." So that was really great. Thank you.
Well, it's because you built it up so much. I was getting ready for this attorney to be like, I know my client did it, and he's a scumbag, and you need to keep his ass in there for as long as he fucking rots. And I'm like, oh, I can't wait.
Well, I'm sorry for being anticlimactic. That's how I saw it. I mean, I still saw an attorney that showed up 20 years later to make a statement. He took the
Definitely
time
unusual.
to write.
Definitely unusual. I will give you that.
I mean, we have seen people who have lost closest relatives show up and say, I've forgiven this person, board. You can let them out. I mean, we've seen all different. So for someone he was punched. I mean, I don't know.
He wasn't just punched. He was left bleeding on the floor, laying there in a pool of his own blood. And for weeks after that, he was suffering pain from the impact, Mandoo. This wasn't just you punch. This was like the court even called it. If you read the line, you can find it. You don't have to do it right now. But the court even said he used the weight of his body to make impact. This wasn't just this was a freaking, swing using the weight of his body to make a person bleed from the eye socket. This is no joke. This was an obvious, I need to do something, and I need to do something now, or else the trial will begin with this lawyer that I don't want.
Yeah, I mean, the guy was a practice fighter. He probably, from his history, he definitely knew how to throw a punch. But it also could have been that he really believed he was innocent, because he was, and he spent 2 years in jail. His family promised him an attorney. They didn't get him one. And then his attorney looks at him and says, you're gonna if you go to trial, you're not only gonna get locked up, but you're gonna be locked up for life. And then he has a hot temper. He's a fight. Boom. So that's a scenario too.
Sure. The attorney made the mistake of not bringing his boxing gloves to the trial. Then he would have been able to block it when it was coming his way. But anyway, on that note, I gotta go.
Thank you, sir.
Thanks for having me, Mandoo. Thank you, guys. I love you all. I love my chat. I love Mandoo's chat. This was cool. We were able to do a collab, and we're streaming. It's called simulcast or whatever. We're streaming
it's a
on
cool
both.
Technology. We have to do this more often.
Yeah, and I don't know how to stop it now.
I'll do it. I'll click the button. I have the powers.
Awesome.
All right.
All right, man.
See ya.
Bye.